Okay, good morning. Sharon Kletchka here in the AMAC Foundation's office in downtown Lady Lake, Florida. We're getting ready for part 2 of our AMAC Foundation's online seminar on women and Social Security. As we mentioned last week, this is the second of 4 parts in the series designed to acquaint women with some of the most important facets of Social Security and to provide the information they need to make the decisions most appropriate to their situation. Just like last week, we need to begin by reviewing our official legal notice, the statement that further defines the information we provide. And I'll just read that legal notice. The views presented today are provided by the AMAC Foundation of Social Security Advisors, certified by the National Social Security Association, LLC. They do not necessarily represent the views of the Social Security Administration. The information presented today does not constitute financial, legal, or tax advice and should be used for informational purposes only. Since individual circumstances vary, you should consult your legal, tax, or financial advisors before making any financial decisions. And lastly, AMAC Foundation is not affiliated with or endorsed by the Social Security Administration or any government agency. Okay, now, with that out of the way, I would like to introduce, first of all, Sharon Kletchka, my colleague here in the Lady Lake office. Sharon's background in accounting and tax preparation covers more than 20 years. She began working for AMAC as a member services representative because she believes in what AMAC stands for and what we're trying to accomplish for both seniors and America. Sharon loves working with the public and being able to help people. That's one of her main skills, is just being able to interact with people and help them. So Sharon, let's begin with a quick look back at what we covered last week. Last week we talked about, in our kickoff session, we talked about some of the basic topics that help set the stage for anyone that's aging into Social Security, including things like how one qualifies for benefits, how the benefits are calculated, and the impact of continuing in the workforce after drawing benefits. That's an often misunderstood part of Social Security. And how benefits are adjusted to account for the cost of living. We also covered the process of establishing a MySSA account, something that we advocate everybody do. If you happen to miss last week's session, you can watch it on our website. Just go to our website, www.amacfoundation.org/videos, and you'll see it there. And then you can just replay last week's seminar. The recorded version of today's session will be posted on the website later today. So, with that as a base, let's dive a little deeper into today's topics. In this second part of the program, we're going to cover some of the more complex areas of Social Security, including the benefits available to women who are single and have never married versus the spousal benefits for married filers. The current details relating to restricted applications will be covered, as well as the concept of deemed filing, something that is very confusing to people, and that there have been some changes since the 2015 Budget Act, so we'll cover all that. We'll also cover the benefits that are available to widows and divorcees. These are the subjects that our Social Security Advisory Service gets the most questions about, and we know it's pretty complicated, and the material we're going to cover today is going to be fairly detailed, may generate a lot of questions, but just know that we're here to help you if you have any questions afterwards. So later on, as time permits, when we get to the end of the session, we'll close with a review of how Social Security applies to common law marriages and civil unions. We'll touch on that at the end. So, hold on one second till I organize my slides. Having one minor problem here with the slides. Get my slides there. Well, we seem to be having some difficulty getting our slides to operate. There we go. Okay, now we're just about on track. So as a starting point, let's take a look at the benefits picture as it applies to women who are single and have never married. If you have never married, your Social Security benefits will depend on your own work record. What you receive in benefits will be determined by how much you earned in your career, how many years you worked, and how old you are when you take your benefits. Those are the primary factors that influence what your benefit will be. As we covered last week, the longer you wait, the higher the monthly benefit will be. If you take your benefits early, however, you may receive a large amount in total benefits received over the long haul. It is a personal decision that only you can make, and it depends on a lot of personal factors. So let's take a look at a chart that should help you visualize this point of deferring filing.
Okay, this chart gives you a quick look at how your benefits grow over time from the early filing point at age 62 to the latest filing point at age 70. As you can see, for someone at age 67, a monthly benefit of 70% of your PIA can grow to 124% of your PIA by waiting till age 70. In dollars, for example, a $1,500 PIA could grow from $1,050 at age 62 to $1,860 at age 70, or a total of an additional $810 per month.
And if you remember from last week, if you were with us last week, the PIA is your primary insurance amount, which is the base benefit that you would receive as a result of the calculation on your earnings record.
And here's another way to look at how your benefits grow over time, this time using dollars instead of percentages. These numbers give you an idea of the point at which the cumulative benefits you receive reach their highest point based on the year you start your benefits. For example, a person starting their benefits at age 67 would need to live to age 80 in order to receive the maximum payout from Social Security. It's really just another way to look at the break-even math that relates to when you start drawing benefits. And if you look across the chart, the figure in reds are showing you if you file, like say at age 62 and you only live to 70, that the maximum amount you would receive would be that $144,000. And the same with the other years, like 67 and you live to 80, that would be your maximum payout.
Okay, Sharon, let's change our focus a little bit from single women to married women. This is where an understanding of spousal benefits becomes extremely critical.
Many married couples do not realize the importance of discussing together when to take their individual benefits. As a married spouse, you have various options available to you for maximizing your benefits. There are rules that could permanently reduce your benefits if you don't coordinate with your spouse when to take them. You can get a spousal benefit on your spousal's record even if you have never worked or didn't work long enough to qualify for one on your own record. As a result of the Bipartisan Budget Act of 2015, some strategies to maximize your benefits are no longer available or not available to anyone born after January 1st, 1954. These rule changes have confused a lot of people as to whether or not they can still use these strategies. The claim and suspend strategy ended for anyone not 66 on or before April 29th, 2016. However, some people are still affected by it if they were eligible to use it before it ended. This rule enabled one spouse to file and suspend their benefits while allowing their benefit to continue growing until they turned 70, while at the same time allowing their spouse and dependents to claim their benefits. The restricted application is still available to anyone born on or before January 1st, 1954. If you or your spouse qualified to file and suspend before April 30th, 2016, and you were born before January 2nd, 1954, you are still able to file a restricted application and allow your benefits to grow up until the age of 70. Another result of these changes is that if anyone were to file and suspend their benefits now, they would also suspend the benefits of anyone entitled to benefits on their record, except for our divorced spouse's benefits. Now, with those explanations in mind, let's take a more detailed look at the issue of spousal benefits, an area that generates quite a bit of activity for our advisors.
Yeah, that's kind of an understatement that Sharon just made. It does generate a lot of questions. And I think I'd like to go back just to be sure you're clear on the dates. In order to use the restricted application strategy, you have to have been born before January 1st, 1954. It's not available to folks born after that date. And that's kind of a stumbling block for a lot of people, and it raises a lot of questions. So I want to be sure that that was understood. So, Sharon, let's dig a little bit deeper into this spousal benefit issue. First, let's explain how and when one qualifies for spousal benefits. And then let's get into the topic that generates quite a buzz every time it comes up in conversation, this thing called the Spousal Boost. And there are some background items that I think you need to understand in order to understand what the Spousal Boost is. So,
generally, you must be married for 1 year before you can get spousal benefits. However, if you are the parent of the spouse's child, the 1-year rule does not apply. A divorced spouse must have been married for 10 years. A spousal benefit is equal to 50% of the higher earning spouse's benefit. If your own retirement benefit is lower than 50% of your spouse's benefit, you are entitled to what is called a spousal boost. Even if you never worked outside of the home, you are still entitled to a benefit on your spouse's or ex-spouse's record. You become entitled to a spousal benefit as soon as you turn 62 years old, but it will be reduced if you take it early. The chart included at the bottom of the slide shows you, for someone with a full retirement age of 66, what reduction would be applied to the 50% spousal boost. The Social Security Administration provides you with a handy calculator that can help you see exactly what these reductions are based on your age and when you'd like benefits to begin. The next slide shows this calculator page on the SSA website, Social Security Administration, and the link, you'll need to access it.
yeah, we thought we would show you an actual picture of the page that when you use that link, this is where you land on the Social Security Administration site. Just this is what you would see. And at the bottom part of that slide, you see where you can enter your information on your date of birth and when you want your benefits to start. So that's what it will look like if you want a precise calculation.
And when you go to that website, enter the website, you'll be taken to the web page where you can enter your birth date and the month you'd like to begin receiving benefits, and the impact will be calculated for you. And by that, it's going to show you the percentage you would receive of your spouse's or ex-spouse's benefit of his full retirement age amount.
Okay. Now, with that behind us, let's talk about this thing called the restricted application. It's a strategy that's popular with many married couples and divorced couples as well. And in this strategy, usually it works this way. The lower income spouse files first, since one spouse must be receiving their Social Security benefits before the other can file a restricted application. That's a key point. One spouse must be already receiving benefits. The spouse filing the restricted application must have reached full retirement age. That's another key point. Once the lower income spouse files, the higher income spouse then files a restricted application for spousal benefits only. And that's the precise terminology you need to use when you do that filing. And in that case, the higher income spouse would receive 50% of the other spouse's full retirement age benefit, regardless of what their age, what age their spouse took their own benefit. This allows for the higher earning spouse's benefit to earn delayed retirement credits of 8% per year up until age 70. Then, when they collect their benefit, the lower income spouse files for their spousal benefit, which would be based on the higher earner's full retirement age PIA. The delayed retirement credits, though, do not increase the spouse's benefit, and that's important to understand as well. It's based on the higher earner's primary insurance amount, PIA, at full retirement age. They do, though, increase the survivor's benefit. We'll get into that a little bit later.
And just a reminder, if your spouse has previously filed and suspended their benefits under the old rules, you are still able to file a restricted application. And divorced spouses are the only ones that can file a restricted application on each other.
And in just a couple of minutes, we'll be getting into the ramifications of divorced spouse filing, so just kind of hold that one aside for now. More on the restricted application.
Just another reminder, if your spouse has filed and suspended benefits under the old rules, you are still eligible to file a restricted application. DRCs do not increase the spousal benefit, but they do increase the survivor benefit. Divorced spouses are the only ones who can file a restricted application on each other.
Okay, Sharon, now let's take a look at this confusing thing called deemed filing. At least it's confusing to me. It's a bit complicated, but deemed filing means that when a person files for benefits and is also entitled to spousal benefits, they are deemed, or in another word, considered, then to have filed for benefits on both their own record and their spouse's record. We'll explain this in a little more detail, but it's a concept that tends to create a lot of confusion for people.
Just as in the case of restricted applications and filed and suspend strategies, the concept of deemed filing also underwent some changes as part of the Bipartisan Budget Act of 2015. The term deemed filing means that when you file for your retirement benefit and your spouse or ex-spouse has already filed for theirs, you are then considered to have filed for both your own retirement benefit and any spousal benefit you may have been entitled to. Deemed filing is also affected by the new rules. Here are the old rules. Specifically for those born on or before January 1st, 1954, you have the option to avoid the deemed filing rule. If you are the lower earning spouse and you want to file for your own benefit while allowing your spousal benefit to increase, you would file for your retirement benefit ahead of your spouse, and then when you reach your full retirement age of 66, you would then claim your spousal benefit. The benefit, however, would be subject to being reduced as you took your own benefit early. Now here's an example of how this works. You retire at 62 on your own work record. Your PIA is $1,000, so you would only receive $750. You become eligible for your Spousal Boost at your full retirement age, and your spouse's PIA is $2,500. Social Security would take half of your spouse's PIA, the $1,250, and they would deduct your full retirement age benefit amount, your PIA of 1,000. This would entitle you to a spousal boost of 250. But as you took your own benefit at 62, your new base becomes that reduced benefit of $750, and your new full retirement age benefit would be $1,000. But you did receive 100% of your spousal boost.
Okay, well, I hope that clears up some of the math on the spousal boost, because we do get a lot of questions about that. Some more thoughts on deemed filing. I know there are a lot of details that go along with it, so I'm going to ask Sharon to just cover a few more points.
Okay. If your spouse filed after you did and you are entitled to a spousal benefit, and now we're still under for people born before January 2nd, 1954. So for that group, if your spouse filed after you did and you are entitled to a spousal benefit, you have to actually file for it. If you have already reached your full retirement age of 66, you should apply for your spousal benefit at the same time your spouse applies for his retirement benefit. Spousal benefits do not continue to grow beyond your full retirement age, so there is no reason to delay collecting them. You may file for your spousal benefit as soon as he files, but it will be reduced if you are not yet your full retirement age of 66. Or you can wait until you reach your full retirement age of 66 and receive the highest benefit possible. It will still be reduced if you took your own benefit early.
And still some more thoughts on deemed filing.
Now, it has been brought to our attention that sometimes spouses simply don't know that they had to file for their spousal benefit. So if this should happen to you and you didn't know that you had to actually apply for your spousal benefit, and you are now beyond your full retirement age and have never received them, when your husband applied for his own retirement benefit and put on his application that he was married, you should have been notified by Social Security to apply for your spousal benefit. You are entitled up to 6 months back pay in spousal benefits. If your husband's application states that he was married and you were never notified by Social Security to apply for that spousal benefit, Social Security may go all the way back to the initial date of his application. The proof is on you. So if you have a copy of his original application, take it with when you go to your appointment. For example, we had a member call in that said he was never informed his wife had to actually apply for her spousal benefit when he applied for his retirement benefit. This entitled his wife to spousal benefits all the way back to the date of his application. She had taken her own benefit at 62, and he had applied for full retirement age at his full retirement age of 66 in October of 2014. He called Social Security on March 17th of 2017, and on April 28th, 2017, his wife received a payment of over $6,000 in back pay for spousal benefits, all the way back to the date of his original application, plus her increased benefit began right away. You may ask them to only go back to the date of your full retirement age. Ex-spouses may only go back 6 months.
So yes, sometimes Social Security will go back and correct their mistakes. So it's a good thing to know about. And yet some more thoughts on deemed filing. Going back to recapping the Bipartisan Budget Act of 2015 and what that did to the concept of deemed filing.
For those born on or after January 2nd, 1954, you will be deemed as having filing for your spousal benefit as soon as your spouse or ex-spouse applies for their benefit, regardless of what age you are. If your spouse or ex-spouse filed before you, you will be deemed as filing for your spousal benefit as soon as you file for retirement benefit, and both benefits will be permanently reduced if you file before your full retirement age.
And believe it or not, there are still some more. Well, that's actually. Well, let's look at some examples of deemed filing.
Okay, say for example, you took your spousal benefit at age 62. Your spouse has not yet filed, so you will only receive your own reduced retirement benefit. Your husband or ex-husband decides to take his retirement benefit at his full retirement age of 66. You are still only 63. You will be deemed as having filed for your spousal benefit and receive any spousal benefit amount you're entitled to at a permanent reduced rate. And that is a big change that you need to be aware of when considering taking benefits. If you're going to be entitled to a spousal benefit, it's your husband's filing is going to deem you automatically.
And that becomes a little bit of a surprise for some people. We do get a lot of inquiries about that. Now let's move in, now that we've covered deemed filing, let's get into the mystical area of widow benefits. It's very complicated. We've tried to boil it down to just a few slides of the pertinent details, but I will tell you it is very complicated, and so we're going to move through some level of detail, and again, if you have any questions afterwards, feel free to get in contact with us. So Sharon, take it away.
Jerry's right there. There is a big difference between widow benefits and spousal benefits, including the full retirement age. The widow benefit is based on the earnings of the person that died. If they're receiving reduced benefits when they died, your survivor benefit will be based on that amount. The maximum survivor benefit is limited to what the deceased would be receiving if they were still alive. If you take your survivor benefit early, it will be permanently reduced. And there is one exception to this rule of the 100% limit, and it's known as the widow's limit, which we will be covering a little further on. Widows get a 2-year dispensation for their birthday, being that their full retirement age is computed as if they were born 2 years earlier than their actual birth date, resulting in an earlier full retirement age, which affects when they can collect their full survivor's benefit. Some of the complications that come into play on widow benefits include the differences in full retirement age applicable to a widow. This chart presented on this slide shows full retirement ages that pertain to widows. If you note, when you reach age 67, for anyone born in 1962, it remains.
Okay, just to recap on that complicating factor, a widow can claim survival benefits as early as age 60 or age 50 if they're disabled. But again, it's important to understand that those benefits are reduced as much as 28.5%. So let's talk now about qualifying for survivor benefits.
The eligibility rules for survivor benefits are as follows. Widows become eligible for a reduced survivor benefit at age 60, 50 if disabled, rather than the normal 62 for retirement and spousal benefits. The current spouse must have been married for at least 9 months unless the death was accidental. An ex-spouse must have been married to the deceased for more than 10 years. The spouse must be currently single. Widowers of any age, if they are caring for the deceased dependent child who is under 16 years of age or an adult child disabled before the age of 22.
So let's take a look, Sharon, at some examples, just to kind of a recap examples of survivors' benefits. What are the kind of benefits that are available to spousal survivors?
Well, the widow of full retirement age of older is entitled to 100% of the deceased benefit amount. A widow age 60 to full retirement age will receive 71.5% to 99% of the deceased basic amount. A disabled widow 50 through 59 will receive only 71.5%. Widow of any age taking care of a child under 16 or disabled, 75%. Child under age 18, 19, if still in elementary or secondary school, 75%. And an unknown benefit to most people is that dependent parents, this is parents that are dependent on their children for their support, and that child should pass away and the parents are 62 or older. One surviving parent can receive up to 82.5%. Two surviving parents, 75% each parent. They cannot be currently married. And these will be subject to a family max, which we will be going into in our next seminar or final seminar. But they are available.
Okay. Thank you for the recap, Sharon. And again, as we said earlier, this is a lot of detail and very complicated. And we are always available to answer specific questions relative to your individual situation. So don't be concerned about contacting us. We know this is a lot of detail, and it's a lot to assimilate in one sitting. So feel free to contact us for more detail on your situation. Now let's talk about something referred to as the widow limit.
Yeah, that's the exception to the 100% of the deceased's PIA. The widow limit is often referred to as RIB-LIM, Retirement Insurance Benefit Limit. The widow limit caps the benefit at the larger of what the deceased would have received if still alive, or 82.5% of the deceased PIA if the deceased claimed benefits before their full retirement age. To simplify what this means, if the deceased started benefits at full retirement age or later, the widow at full retirement age would be entitled to 100% of the amount the deceased was collecting. But if the deceased had started benefits before their full retirement age, the widow would, at full retirement age, be entitled to a minimum of the deceased PIA, or a minimum of 82.5% of the deceased PIA, or the amount the deceased would have received at full retirement age. If you are affected by the widow limit, your survivor benefit might reach the maximum benefit amount before you reach your full retirement age. An example is, at the current full retirement age of 66, the widow would only have to wait 24 months or until age 62 to receive the full amount of the benefit, as it would no longer continue to grow. And if your spouse should pass away before their full retirement age, you are entitled to 100% of their PIA at your full retirement age. Now, how this actually, where you get the 82.5% limit is, if your spouse, Pat, took his benefit at 62, he's only receiving 75%. Should they pass away, you'll actually receive that higher benefit limited to 82.5%.
So it's sort of a bonus. You can look at that as sort of a bonus for a surviving spouse where the deceased spouse had taken reduced benefits, taken early benefits. So it's sort of a bonus. Another way to look at it. Let's talk some more about some of the other considerations on widow benefits.
Okay, widow benefits were not affected by the Bipartisan Budget Act of 2015, and they are not subject to deemed filing. If you file for your survivor benefit before the age of 62, you may switch to your own retirement age benefits anytime before you reach your full retirement age if it will result in a higher benefit. But remember, it will be permanently reduced. If you are already 62 or older, you have the option to restrict your application to either your survivor benefit or your own retirement benefit. You need to do the math to determine which is the most advantageous. For example, if your own retirement benefit will be higher at the age of 70, you can restrict your application to your survivor benefit only. This allows your own benefit to continue growing up to the age of 70, accruing delayed retirement credits. If your survivor benefit will always be the highest, you could restrict your application to your retirement benefit only, should you want to take it early, and then claim your higher survivor benefit as your at your full retirement age, as once again, survivor benefits do not grow beyond your full retirement age. Survivor benefits do not accrue delayed retirement credits, although COLA increases between the time your spouse died and you began collecting benefits would apply. Another important thing to remember in making your decision, if you take any benefits before you reach your full retirement age, you will be subject to an earned income limit. If you switch to your own retirement benefits before you reach your full retirement age, any survivor benefits you lost to going over the earned income limit are permanently lost and will not be repaid. There is also a one-time lump sum death benefit of $255 that is available to the surviving spouse or dependent children if they were receiving benefits or became eligible for benefits upon the death of the worker. You only have 2 years to claim this benefit.
Okay, again, that was a lot of detail. A lot of detail in one sitting, and again, don't be concerned about contacting us if you have any questions relative to your specific criteria. I'd like to now move into the issues related to divorced spouses. That becomes another complicated area, and let's begin with a discussion of that.
Social Security provides divorced spouses benefits just like they do spouses. Many times you can receive a larger Social Security benefit based on your ex-spouse's work record than on your own. Social Security Administration will calculate each benefit for you, but you will not receive both benefits. You will receive whichever is the higher amount. You can receive Social Security benefits without filing any special papers at the time of divorce, and it doesn't matter if your ex-spouse has remarried. As a divorced spouse, you must meet certain criteria to collect benefits on your ex-spouse's work record. You must have been married for 10 years or longer. You must not be currently married. If you remarry, you generally cannot collect benefits on your former spouse's record unless your marriage ends later ends by death, divorce, or annulment. If you remarried and your second spouse is deceased, you qualify to claim benefits from either your first spouse, if that marriage lasted at least 10 years, or your second spouse, as long as you were married at least 9 months before he died. You must be age 62 or older for spousal benefits if your first spouse is alive. If your first ex-spouse is deceased, you can collect at age 60 as a surviving divorced spouse. If your ex-spouse is deceased and you are disabled, you can collect at age 50. You do not have to wait for your ex-spouse to start receiving his benefits if you are an independent divorced spouse. If your age is 62 or older, you can start receiving your benefits if you have been divorced for more than 2 years, as long as your ex-spouse is at least 62 or on Social Security disability. You are eligible to receive 1/2 of your ex-spouse's retirement benefit. The spousal benefit does not include any delayed retirement credits your ex-spouse may receive. You can only receive a benefit based on his full retirement age. If your ex-spouse should pass away before you do, you would then be entitled to 100% of his benefit, including delayed retirement credits. If you are receiving divorce spouse benefits when your ex-spouse dies, you will automatically be switched over to the higher paying survivor benefit. Even if your ex-spouse should remarry, it does not affect your entitlement to a benefit on his record or the amount of his current wife's benefit. If you qualify for benefits based on your own work history, you'll receive the larger of the two benefits. You cannot receive benefits on both your own record and your ex-spouse's work record. You'll need your ex's Social Security number to receive it, but if you no longer have access to his Social Security number, you will need to know his birth date and his parents' names. Ex-spouses have been known to have trouble finding out the amount of their ex's benefit, and you will need to know that to help make your retirement decision. You will also need to show proof that you were married for at least 10 years and that you're entitled to this information. If the person you speak with refuses to give it to you, ask to speak with a supervisor or manager.
Okay, Sharon, let's talk now about a term that sometimes causes confusion, this concept of independent divorced spouses. No, we already covered that. We don't need to. That was a duplicate.
Okay. Okay. If you are receiving an ex-spousal benefit and remarry, you will lose the right to those benefits unless the subsequent marriage ends through death or divorce. If you marry someone that is receiving Social Security benefits, you are not subject to the 1 year of marriage rule to receive a spousal benefit on their record. Your benefit on your ex-spouse will end the month before you remarry. You only have to be married for 1 entire month to claim your spousal benefit on your new spouse's record. If your new spouse is not yet receiving their benefit, you will not become eligible for a spousal benefit until they do. There is an exception to this rule if a divorcee that is receiving benefits on an ex-spouse's record marries an individual who is receiving a widow's or divorced spouse benefits. Your benefits on your ex-spouse's record will not stop as a result of that marriage. And not to cause any confusion, just a reminder to widowers receiving widow benefits, that remarry after age 60, you are able to keep those benefits.
Okay, once again, this is a very complicated area, as you can see. We encourage anyone that needs specific guidance to contact our advisory service for help. And now to wrap up this week's segment of the seminar, we'd like to take a quick look at an area that often also generates some confusion: common law marriages and civil unions.
Well, common law marriage is only allowed in a minority of states. Not all states have statutes addressing common law marriage, and in some states, case law and public policy determine validity. However, if you established a common law marriage in a state that allows them and move later, any state must acknowledge that marriage. This means you can get Social Security survivors or spousal benefits in any state as long as your common law marriage was created in a state that permitted it. If you have questions about the circumstances leading to common law marriage, including the duration of cohabitation, you'll need to contact an attorney, legal services organization, or the clerk of court near you, since the specific rules vary from jurisdiction to jurisdiction.
Okay, that really concludes our content for this week. I'm going to open the chat room now. If anybody has any specific questions at this point, feel free to submit them. In the right-hand corner of your screen, you'll see the chat window. Just enter your question at the bottom right, and we'll see if we can help you out. Looking ahead to part 3, this is what we're going to cover next week. We're going to talk about benefits for dependents. We're going to talk about children's benefits. We're going to talk more about the dependent parents' benefits. And we're going to get into the area of Social Security disability insurance, another pretty complicated area. And we'll cap that all off with a discussion of the family maximum, how that applies to all of the benefits that are covered. We are also then in week 4 going to get into the subject of the windfall elimination provision, commonly known as WEP. We're going to get into the government pension offset and the implications that has for spousal benefits. We'll get into the taxation of Social Security benefits, how you determine how much of your Social Security benefit is subject to personal income tax. Then we'll talk about special lump sum death benefits, receiving benefits abroad for people that have moved offshore. And we're going to close out the session, the final session, with a discussion on Medicare, specifically its home harmless provision and a concept called IRMA. So with that, we're going to conclude, and I see we have a question here. Is it different if your spouse was collecting Social Security disability when they passed away?
No, it isn't. When someone's receiving Social Security disability, they're actually receiving the maximum they're going to collect, and that's the amount the surviving spouse would receive should they take the benefit at their full retirement age.
Okay. Are there any other questions? Okay, well, is there a time limit on how long the person has been dead that I can collect?
No, there isn't, as long as they qualified at the time of their death, and you become eligible to file on their record at least 60 years old, 50 if disabled. There is no time limit. They actually do add all the COLA increases from the time of his death to the time you file.
Okay, any other questions? We will just leave the chat window open for a couple of minutes. And just a reminder, part 3 will be next Tuesday and part 4 the following Tuesday. And again, all of these recorded sessions are available on our website, amacfoundation.org/videos. And the recorded version of today's session will be up later today, available for access. Okay, I don't see any other questions coming into our chat room. So with that, we'll end the session for today, and we'll see you all on part 3 next Tuesday morning, 10 o'clock, same time, same place. Thank you very much and good day.